All right. Let's see. So if that puts you to sleep. I know my lecturing puts you to sleep, but the lights don't help either. So chapter 3 is about courts and the legal process. It seems like most of you are getting the pattern down, that there is a beginning of the chapter assignment, which is the quiz questions, and then an end of the chapter assignment, which is due by the day that we start the new chapter. Okay. If it'll make you feel better, you can do it the day before we start the new chapter. That's up to you, but it's due tonight. So chapter 2's regular assignment is due tonight, as well as chapter 3's questions, right? I think everybody's kind of getting that pattern down at this point. The questions have been good. And like I said, I appreciate that you think about it. If everybody in here does 5 questions, that's something over 100 questions. And probably out of that, I get 30 or 40 that are sufficiently different enough from each other. That means that you're reading through the chapter and not just everybody picking the same stuff from one little spot. Okay, so that's good. Understanding courts and the legal process doesn't always seem that important unless, of course, you are in the clutches of the court or legal process, at which point you say, I wish I knew more about how this whole thing worked. Because most of us, our study of the court process kind of like entails watching like SVU, and that's it, or something like that. So we're going to talk about the 2 different court systems in the United States, which is really way more than 2 court systems, but it's technically 2 systems. And talk about jurisdiction, how we decide which court can actually hear which case. And then the process kind of that things go through, and finally alternative dispute resolution is sometimes called ADR. They call it alternatives to litigation. So that's kind of what we'll cover in this chapter. So when we talk about 2 systems, what we mean is there's a federal court system and a state court system. And the reason I said it's actually like a way bigger system than that is every state's court system is a little bit different. Right? This is one of the things that confuses people from every other country on earth when they deal with the United States, is like how we can have these states that we recognize as sovereign in many ways, but still be part of the same country. Almost every other country on earth has a strong federal government. We have a strong federal government here too, but where courts and things like that all happen kind of at their federal level, at their national level. But in this country, hey, if you murder somebody, you're not going to be tried in federal court unless the federal court has jurisdiction, which would be some very limited cases. You're going to be tried in a state court. And that's why our state superior court judges, like we have Mike Peterson here in town, they have a great deal of power. I mean, they can levy the death penalty. They can send you to prison for life, which is scary to me because I've known Mike a long time. And no, he's a great guy, and I think he tries to be a really fair guy and a decent guy, but like he's still a regular guy in that sense. And I'm like, man, does that ever freak you out? And it's like, absolutely. Like, would you want a judge who wasn't a little disturbed by the fact that they had the authority to send somebody to prison for life? We like that, okay? So the federal system, it starts with the district court, and that's what it says. It's the general trial court in the federal system. So if you have a case that has federal jurisdiction, that's the first place you're going to end up, is in the district court system. There's something like 90, I'd have to look, 90 plus federal district courts. Each state has at least one, and then states that are big and have a large population have additional. Also, the District of Columbia has a federal district court, and I think some of the U.S. territories do as well, if they're big enough. So they have jurisdiction over the subject matter when the United States is a party to legal. So if anybody's suing the federal government, it's going to be tried not in a state court, but in the federal district courts. If it's a federal question, meaning it's about like a federal law statute, okay? Or if there's a diversity of citizenship, meaning if 2 members or 2 citizens of the United States from different states, one sues the other, then that becomes a diversity of citizenship because they can't decide which state should have authority over the case, so the federal district court takes it. So that's when they're involved. Um, this is an interesting fact right here. What law will be applied to a case? And so when say you have a diversity of citizenship case, the first thing they have to decide is, are we going to be applying federal law here or state law? And if state law, then which state? And so there has to be this decision as to, well, where did the offense occur? And so when there's a diversity of citizenship, they typically apply state laws according to the state where, so this is why trials are so expensive, right? Because you have to go through this whole process of both lawyers arguing, well, it should be according to the laws of this state or according to the laws of this state, and then they have to make a decision on that before they can even move forward with the rest of the case. 97 federal districts. See, I knew it was 90 something. Each state, Puerto Rico, DC also have districts. Virgin Islands, Guam, and they all have a single, I guess they have a federal court, but I think it's part of a single district. So you can imagine someplace like California and New York, they're going to have multiple federal districts there just because of the number of people. Think about it. New York City has more people in the city limits than the state of Arizona has in the whole state. And we're not a tiny state. And so, they're going to need more. That means the mayor of New York has as much power as like a governor of a lot of other states as far as the people that they're responsible for. As much power and as much headache, those two things come together. All right. There's also specialized federal courts, or sometimes they're called courts of limited jurisdiction, which means they only take cases of certain subject matter. And those are up there. I won't read them to you. But if you think about it, it makes some sense because some laws are so specialized. There's attorneys who make their whole career just doing tax law, because it's if you ever look at the United States tax code, it's ludicrously big. That's why people. Have you ever heard people who are like flat tax supporters? Right? I'm not opposed to the idea of a flat tax. There's two notions of a flat tax. One is that it would be the same amount of tax for every person regardless of their income. A second is like a flat percentage, like everybody pays 10% of their income. So if you make $1 million, you pay $100,000 in tax. If you make $1,000, you pay $100 in tax. And this is appealing in some ways. They've actually shown that a flat tax of around 8% would actually create more revenue for the government than our current tax system, where some people are taxed at 60% and some people get money back that they never paid in, right? And so there's some appeal to that. But I don't think it'll ever happen because there is a lobby by a whole bunch of people who make their living running the tax system and defending cases. And so all of these lawyers, everybody who works for the IRS, every CPA, think of how badly they'd be hurt if the entire tax form was, how much did you make according to what your employer sent you on the W-2, multiply by 0.1, this is your tax. There would be a lot of people out of jobs, right? They'd have to go into some other form of law. Anyway, so it makes sense when you think that there are specialized laws, and therefore there are courts who hear very specialized cases at times. Above the district courts are what's called the Court of Appeals. So if you get your day in court, the district court, and then you feel, your attorneys feel that there was some reason that trial wasn't fair, you appeal the case to the Court of Appeals. There's 13 federal circuits in the Court of Appeals. Typically, when you go to an appeal, you'll see 3 judges. They'll review the case from the federal district court, and then they'll issue an opinion. That review entails them reading all of the notes from the previous case, plus the briefs submitted by the parties in the case, saying this is why we feel we have why we feel we have an appeal here. And then from the other side, they'll write a brief saying this is why we think there isn't an appeal here. And then there's what's called amicus briefs. Amicus is Latin for friendly, okay, which are filed by people who feel they have an interest in it. So for example, if it were an abortion case, in addition to the 2 parties, Planned Parenthood would file an amicus brief saying this is why we think that this opinion is good or bad. And maybe, I'm trying to think of some of the Right to Life coalitions. They would file briefs as well, right? So you have all these parties saying this decision is important, and this is why we think that it's not right or it is right, and this is why we think the appeal is warranted or not warranted. Right or not right doesn't factor in nearly as much as, this is the legal reason why we think that you should consider this appeal. So the three judges review the case, and then they issue an opinion. If after appeal, someone doesn't feel that they have had a fair trial for some reason, or they feel that this is a case of something being unconstitutional, they appeal again, and it goes to the United States Supreme Court. The Supreme Court gets so many cases appealed to them that they can't take all of them. In fact, they take less than 10% of what's appealed to them. If they do, they issue what's called a writ of certiorari, which is a really weird Latin term. And I used to always worry when I taught this class that I couldn't pronounce the word writ of certiorari. And then there was a really cool article, I forget which magazine put it out, that interviewed all of the justices of the United States Supreme Court. And with 9 justices, they had 7 pronunciations between the 9 of them as to how to pronounce that word. The problem with Latin is it's a dead language. No one's ever heard the people who once spoke Latin as a real language. So we just have to make a guess. All right. That's just an interesting aside. It won't be on a test. Right. How many ways can you pronounce? Okay. So the Supreme Court decides to review the case. If they're going to, they issue this writ of certiorari, and then they will, and they call it the rule of 4. If 4 justices decide to review it, even though that's not a majority, then the idea is if 4 out of the 9 decide this is something worth looking into, then they'll look into it. That's the idea. So they don't. It's not a vote. It's not a law that they do that. That's just the process they've used, is saying, hey, if that many of us think this is worth reviewing, then let's take a closer look. Okay. The Supreme Court actually has a original jurisdiction. That means a case can actually start with the Supreme Court in a couple of very small cases. One is disputes between states. So if one state is suing another state, it doesn't go to a district court. It goes straight to the Supreme Court, and they hear it. So if there's a dispute over, I don't know, the border between between Arizona and New Mexico, or a dispute over who's going to pay for costs between 2 states or something, that would go straight to the Supreme Court. If you think about it, it happens all the time. Anybody here from Duncan? One person from Duncan? So where do kids from Verdon go to high school? Duncan High School, if they go to public school. Well, Duncan's in Arizona and Verdon's in New Mexico. So the question is, who pays for that? Well, luckily they worked it out on their own. The 2 states got together and said, hey, you're going to be bearing the cost of some of our students, and it probably happens in other border areas too. But if there was a dispute as to that, it would go to the Supreme Court. Also, charges of espionage or ambassadors and foreign consuls. So if a foreign ambassador is going to be charged with something, it goes straight to the Supreme Court. Most of the time, you know what happens if we figure out an ambassador from a foreign country is spying on us? You know what we do? Nope. We ship them back to their own country. Because, well, guess what our foreign people are doing in those countries? People who work in embassies, they're not all just stamping visas, okay? Anyway, I have stories I like to share with you, but not right now. So Supreme Court justices have a lifetime appointment. That means once they're appointed, and they're appointed by the President of the United States, and then they're confirmed by the Senate, once they're appointed and confirmed, they will stay a justice until either they retire by their own choosing, or they die, or they're impeached. It's pretty hard to impeach them, because you can't impeach them just because you don't like their opinions. There has to be some sort of reason, okay? So they stay forever. And if you've watched our current president, this is something he's actually been pretty good at, is while all of this tempest is roiling about the things he tweets, he's appointing judges to lifetime tenure positions. that are quite conservative. Some of the people he's proposing are like, and this is Supreme Court, but also any federal judge. So the federal district court justices and the federal appellate appeals court justices, those are all lifetime appointments. And so if a president of the United States can get their judicial agenda working, which means getting justices appointed or judges appointed, they kind of leave a mark that lasts well beyond their presidency. We have judges right now serving that were appointed by Carter and Nixon. Those are the old ones. But a lot of Reagan judges still in office. Okay, and you guys don't remember Reagan. Reagan was president when I was a kid. From 80 to 88. So from the time I was 6 until I was a teenager. And he appointed a lot of judges, and they're still there. So Trump has been. It's been interesting to me. I don't know what he's doing because he's one of those people that I look at what he says and I think this guy's crazy. Like he just spews crazy stuff a lot of times. But I wondered if it's been an obfuscating tactic. When you open the newspaper and the lead story is Donald Trump tweeted so-and-so about so-and-so, and then the next big trending story is, what's his last name? Melania Trump wore inappropriate stiletto shoes while they were going down to visit victims of a flood. And the next big trending story is Don Jr. shook off his Secret Service patrol so he could go moose hunting in Alaska. And that's what dominates. And then on page 3 is Immigrations and Customs just swept sanctuary cities and deported 250 people. And down on page 3 is 56 federal judges appointed to lifetime tenures. I think maybe this guy's playing a game. Not a game, he's playing the game. And maybe he's smarter than I thought he was, because he seems like an idiot, to be honest, sometimes, so the stuff he says. And that's without even talking about whether or not you like his policies. Just, if the way he talks is pretty offensive at times, right? And so you're watching, and it's easy to get caught up in that, and then down here he's appointing judges and doing the real work of the presidency. Anyway, so it'll be interesting to watch. This is not me trying to take a side. This is me just sort of observing and thinking that was smart. Get them, feed the media fake news so that it buries the real news, especially because right now we live in a world where, does anybody have like an iPhone or an iPad and you get the little news app? That's driven by what's trending. It's driven by how many people are clicking through it. That's what comes to the top of your feed. Kind of like Facebook or other things. Occasionally they'll force things to the top of the feed, but there's a section called trending news, and that's click-throughs. And so if you can feed them something salacious enough that everybody wants to click on it, then it keeps your real agenda down on page 3, and that's interesting. All right. Anyway, so Supreme Court lifetime tenure, and they report their opinions in this something called United States Reports. This matters. Like back a second ago, I said that the Court of Appeals, they get their opinions in the Federal Reporter, and this one's called United States Reports. This matters because remember the whole concept of stare decisis, of let the decision stand. There has to be like a central database for all of these opinions, because they have to look at what opinions have been made before as they're making new opinions. Just so you know, the 9 members of the Supreme Court are not the ones looking up all those opinions. They have clerks. Usually to be a Supreme Court clerk, you're the best and brightest kids in law school, not kids, young adults. And then after they graduate from law school, they get a chance to be a clerk for the Supreme Court for a year or two, which is super awesome on your resume, right? Because it means you got to know all of the justices of the Supreme Court, and then every firm on earth wants you because you've built relationships there, right? So it's usually very competitive to get those slots, even to get the slots as clerks to the appellate courts. And so they're the ones that will say, we're taking this case, now you go do all the research as to what cases that have already been decided might possibly come to bear on this. And then they start the process. They also do something really cool that I think is cool in a lot of appellate cases, and especially in Supreme Court cases, is they do something called oral arguments. So it's different than like the court drama where you have a jury. There's no jury. Instead, in addition to these briefs everybody's filed that kind of states their case, lawyers from each side get to stand before the Supreme Court, all 9 justices, and make an oral statement, 10 to 15 minutes, usually 5 to 10 minutes, and then they get grilled by the justices. The justices will say, well, how is this different than this? So they'll pull up these cases and say, how is what you're asking us to change different from what we've already stated in this case? And the lawyer has to answer that. And you can actually either listen to audio, or sometimes there's video, but it's usually audio of these, and they're actually pretty interesting because these justices, think about it, they're appointed for life. They can't go any higher. And so they're like fearless in attacking these lawyers. They just go after them, and both sides. So then the other lawyer gets up there thinking like, yeah, they really abused the last guy. They're going to be on my side. And then they rip into that lawyer because what they're trying to do is poke holes in their arguments. Then they go back and they deliberate. They talk amongst themselves, and then they vote. And what they vote on becomes set. It doesn't change. Who can change it? Nobody, because they're the Supreme Court. So it's a lot of power, right? I mean, it's kind of crazy, actually. So in state court systems, it's very similar. They have what we call lesser courts. If anybody ever had to go to the JP, probably if you got a ticket, or a municipal court, right? City judge. That's for things like tickets or breaking city ordinances. They're usually pretty minor. They almost never involve jail time. They almost always involve fines or maybe some probation or something. Occasionally, something could happen in a JP court. Like you could go to jail for criminal speeding or something like that, or for criminal trespass. But they usually are limited. I'd have to look in Arizona at what it is. 30 to 90 days in county jail is the worst they could give you, or something like that. If it was going to go beyond that, they'd have to bump it up to the Superior Court. So what they call general trial courts in Arizona, they're called county superior courts. So ours is called the Graham County Superior Court. Judges in Arizona in trial courts are elected by the people, directly elected. And they have a specific term. So they have to, the idea behind that is they have to make sure they serve the people of that community, right? And if the community's makeup shifts and changes, then probably who they'll elect might too, right? We have a state court of appeals and a state Supreme Court. So if you get charged with something as a crime on the state level and you appeal to the state court of appeals, and then you still think you didn't get a fair trial, you go to the state Supreme Court. If the state Supreme Court decides, you can appeal one more time to the federal Supreme Court. And whether that's a civil suit or a criminal suit, you can appeal all the way up to the federal. So appeals from the state Supreme Courts go straight to the federal Supreme Court, not to the federal appeals court. Yeah. Okay, good question. So Judge Judy is, first of all, she's not a real judge. She once was, okay? But now, at the end of this chapter, we'll talk about something called alternative dispute resolution, ADR. And two parties can say, both agree by contract to, rather than going to court, they will allow a third party, a lot of times they call it rent-a-judge, actually, a third party, a judge who's like a retired judge, to hear their case and decide it, and that they'll be bound by it. They both, and the reason they'll do that is because when something goes into the court system, it becomes public record. So let's say you have a nasty divorce, and it's going to like drag out the affairs and all these terrible things, and that becomes public record. The parties might decide, we don't want this to become public, so we'll hire we'll rent a judge, and so Judge Judy is like a form of that, except instead of agreeing that it's going to be private, you agree this is going to be public. And what they do is they get some compensation for going on the show. Like usually both walk away with some money, but the winner gets more money than the loser. So it's kind of like it'll pay for the fine, plus you'll each get some compensation for letting us use your dirty laundry on our television show. And so so it's a form of alternative dispute resolution that becomes contractual. Both parties sign a contract saying we're going to agree to drop our any claim to a suit outside of this and let it be decided here. Does that explain it? Yeah. Judge Judy. It is entertaining to watch people blow up their lives, isn't it? All right, so who has jurisdiction? Jurisdiction just means the court's authority to hear the case. So there's two types that have to be decided on. The first is called subject matter jurisdiction. And so pretty simple. If it's like a state law was broken, well, then the state has subject matter jurisdiction. A federal law was broken, then the federal courts have subject matter jurisdiction. Where it's not always clear are these sorts of diversity cases where it's like, well, this is from the state of Arizona and the state of New Mexico, so we think the federal courts. But remember, if the person bringing suit thinks that, say, the laws of the state of Arizona would be more beneficial to their winning the case, then they're going to fight and make an argument as to, so before the trial even gets going, there'll be this argument over where jurisdiction should be. And in the modern era, it's very difficult because even if you're a resident of New Mexico and I'm a resident of Arizona, if you came to Arizona and damaged my property, Arizona would have clear subject matter jurisdiction, right? The event happened in Arizona, so we can do that. But what constitutes presence in a state? If I'm selling stuff over the internet and I've been in Iowa this whole time selling stuff and then you don't like my product, is the fact that you sold it in Arizona mean it's subject to Arizona or not? And so these cases, there's actually, some case law that they've had to work out of that. And what they've come up with is if you have a physical presence, like say Walmart, who's actually headquartered in Arkansas, if they have a physical presence in Arizona and you harm me in Arizona, I can sue you in Arizona courts. But if you have a non-physical presence, like say just a web-based one, then that's going to be a federal question. But it's not always the same. In fact, there's always like these minute things, right? Because then, so they'll say you can sue them in federal court on that one, and then someone will say, well, what about this? What if they have a person who works for them in Arizona? Is that enough? So they'll always try to fight it. All right, so subject matter jurisdiction, just know that it means which court has jurisdiction over the subject matter of the case. Typically that means if it's a federal law, the federal courts; if it's a state law, it's a state court. If it's a diversity of citizenship, it's a federal, and so forth. And then the second is what's called in personam jurisdiction, which is Latin, and it means in personam, to the person. In other words, the parties in the case, who has jurisdiction over them. And of course, that's the state they live in. Okay, so they have to solve this whole issue of jurisdiction before they can even start a trial. And that's crazy. So the parties that are dealing with these cases, you have plaintiffs and defendants. Plaintiffs bring a lawsuit. Defendants are the one being sued. Okay. What's interesting, though, is when we appeal a case, the names can get flipped around. So if I bring a suit, I'm the plaintiff, and the defendant loses, so I win the case as a plaintiff, the defendant loses, and then the defendant appeals, now they became what's called the appellant, the person appealing, right? And I become the appellee. And so now, in essence, they're the one filing suit because they've appealed it to the higher court. So it can get confusing sometimes. You have to kind of track who's whom. Who is who? Who is who, not whom. All right. So here's how a case proceeds. Did I tell you guys about, what was the guy's name? Ammon Bundy? The guy, I thought, the rancher who got put in jail by the BLM, and then the judge threw the case out because they said that they did not provide information that was helpful to his case to him. So the first thing that happens is what's called a complaint. So if it's a civil case, I, in essence, have my lawyer write in specific terms what my complaint is. Who did what to harm me, in what way. And then that complaint is issued, and the court issues a summons to the person I'm complaining against that says, you need to appear and speak for yourself on this matter. This so-and-so is suing you. Here's what their complaint is. And so usually before they even appear, they'll reply with what's called an answer. And the answer will say, it'll take each line item. So if I say, as of this date, so-and-so was a resident of the state of Arizona. They were driving my child in their car. They did not see that my child was buckled, and because of this, my child was harmed in an accident. Their answer will say something like, I agree to the first point. We were, in fact, residents of Arizona at that time. I agree to the second point, but I disagree or cannot answer to the others, or something like that. And so what that does is it allows it to move forward and saying, okay, both parties agree that they're residents of Arizona. We know who has jurisdiction. Both parties agreed to the date in question that there was an accident, but the parties do not agree that the kid was not buckled, or they do not agree that it was the fact that the kid was unbuckled that got the kid hurt, or whatever, right? So that's the way it works. So after the complaint and summons, then they go to jurisdiction. They decide who has jurisdiction and what venue will hear the case. That could matter. I'll give you an example. In Graham County, we have a single Superior Court judge. His name's Mike Peterson. Well, I've been involved in scouting and other activities with Mike Peterson for the last 15 years. I could imagine if someone was suing me, them saying, we do not want this case to be tried in Mr. Peterson's court because he's friends with the defendant. Not saying he wouldn't be honest, but it just isn't good, right? So they could file for what's called a change of venue. Our first change of venue would be to go to, we have a Superior Court judge pro tem here, meaning he's not elected by the people. He's hired by the main judge because they have too big of a caseload to hear some of the other cases. His name is Corey Sanders. He handles most of the juvenile cases and things like that. Well, Corey Sanders and I have been friends for about the same amount of time. It's a small town, right? You get to know people. And so at that point, they would probably say, can we have this court heard in the Greenlee County Superior Court? Because I don't know anybody in Greenlee County. I mean, I know some people, but I don't know the judge there. So that's why these things can take months and months and months to work through, just to make sure everything's up and up. So here's the service of process and personal jurisdiction. That means subpoenaing people to give statements and stuff like that to figure out for sure who has jurisdiction over the people of the case and to get everybody's statements. Through this process, then we do the initial pleadings. This is me saying I am responsible for this or I'm not responsible for this if I'm being sued. There's also a motion to dismiss, which means clearly this guy has not brought enough evidence forward for this to even go to trial. Judge, can you just dismiss this? And it happens more than you think, because a lot of lawsuits are baloney. So people are just trying to sue them to give people a hard time, and if they can't really produce enough evidence to show that something should even be heard, the judge can just dismiss it. All right. If the judge does not dismiss it, it goes to what's called discovery. This is an interesting thing, because even though our system is adversarial, meaning the lawyers are working against each other, it's also collegial in the sense that there's an obligation for parties to share information with each other. To say, we have this information on you, and it's damning to you. Or we have found this information in our... Because the intent is justice at the end, not for one party to win or not. But I think there's enough egos involved that it becomes that, right? But the idea is, if the sheriff's department, while investigating this crime, finds information that clearly shows that the defendant is innocent, they have an obligation to share that information, because they're not out to get an innocent guy. They're out to get justice. So discovery, and that's what's up with this Ammon Bundy case, is the federal judge said, you had information that clearly protected this guy, and you hid it or suppressed it and left him in jail for 700 days as you were going through this process of discovery. And then they bring it to court, and the judge looks at all this, and again, Bundy is like this hardcore kind of right-wing conservative guy, and this judge was like an Obama appointee. So people aren't even able to say, well, this is just political motivation. This is a judge who probably personally disagrees with the guy, but says, hey, federal government, you behaved inappropriately here, and threw the case out. And so that's what's interesting to watch now. I don't know all the details, but that's as much as I know. After discovery, there's a pretrial conference. where the parties and their attorneys kind of spell out where they stand. That's kind of to get it down where everybody is before the trial starts. Sometimes what they can do is in that pretrial conference, they can decide, hey, we're not going after them for these things. Or they can decide, of all these concerns or all complaints I have, let's get rid of all the fluff and focus on this complaint because this is really the heart of the matter. Okay. If you think about something like a divorce, divorces are nasty. And sometimes you'll have people, who've spent 20 years together and they're mad about everything. And if you can get them to sit down and say, of all these things you're mad about, like, what's the heart of the matter here? Was it the way he treated the kids? Was it the way, was it an issue of adultery? What was it? Because that lets us focus on these matters and not drag everything else out into the open that doesn't need to be. All right. So after pretrial conference, we have the trial, and that's just like you've seen on TV. You didn't know all this happened before the part on TV, right? And then decisions made at the trial. After the trial, there's something called post-trial motions. The most common is something called a judgment NOV. That means a judgment notwithstanding the verdict, but it's something in Latin. I don't remember it. That's where the person who loses the case can, in essence, make a motion to the judge that the judge consider, even though the jury decided this, that the judge make a judgment the opposite way, notwithstanding the verdict. That happens on occasion, where a judge says, this jury got it wrong. And so the judge can actually overrule the jury and do what's called a judgment, notwithstanding the verdict. The thing with doing that is it guarantees this thing's going to be appealed, right? I mean, immediately the party's going to say, whoa, the jury decided in my favor? You screwed me. And so the judge has to be like really certain that doing that is defensible because it's going to go to the next level. Judges do not like to be overturned on appeal. Right, it makes them look like they didn't apply the law well. It makes them look like an idiot. So they're usually very careful to try to not have something be that will get appealed. All right, after that, then you have the judgment and order. So if we settle these post-trial motions or there's none, then the judge actually says, this is what's going to happen. You're going to go to jail for 8 years, or you're going to pay this guy $200,000 or whatever, and then appeals. As much as it sounds like everything gets appealed, it's very common for things not to get appealed, for that judgment at the Superior Court to stand, and that's it. Because you have to have a case behind it. You cannot appeal on the basis of, well, I didn't like the decision. Like, that's not sufficient. It has to be something wasn't done right. There was either a procedural error here, evidence wasn't allowed that should have been, or evidence that shouldn't have been was, things like that. Those are reasons for appeal. So I mentioned alternative dispute resolution. There's others like rent-a-judge, but the two most common are called arbitration and mediation. Arbitration, well, let me talk about mediation first. Mediation has to do with both parties agree to hire a mediator. That's a person who will hear both sides and try to help people work through their problems and just sort of settle their problems. Because you think about it, if you and I are disagreeing about how much I should have paid you for something, and we can both get somebody who will kind of listen to both of our sides and then sort of maybe help me realize I'm being unreasonable about some things and help you realize you're being unreasonable, and we can find like this middle ground, and I pay you and we walk away, we're probably both winners compared to going through months and months of trial and paying lawyers hundreds of dollars an hour for all of that time. And the other bonus is it's private. So if you and I can agree to hire a mediator and work through it together, nothing goes in the newspaper. Nothing goes in the public record. And, most of us have probably done things in our life that we're not proud of. And the last thing we want is that thing that we're least proud of in our whole life to make the headlines of the newspaper, right? Because just like I kind of said, sometimes the reporters are lazy and they just comb through tweets to find the next story to write. Well, there's another whole group of reporters who they just comb through the court records, right, to dig up what they can that they think will sell newspapers. Or, well, either that is legitimate news, Sometimes there's legitimate news, but other times it's like, is this salacious and dirty enough that people will want to read it, right? Because that's part of what our news system makes money off of. If it was boring, nobody would care. They can't sell ad space on boring stories. So that's another bonus of this alternative dispute resolution, is keeping it out of the public trial. So arbitration is different in the sense that, so mediation, if at the end we still can't come to an agreement, then usually we can still take it to court. Under arbitration, there's kind of two categories of it. One's called mandatory arbitration, the other's called non-binding arbitration. But here, rather than have someone who tries to like work it out between us, instead we have someone who's an arbitrator. They hear both sides and then they make a decision. Okay? And in non-binding arbitration, they make a decision, and I can either say, hey, I appreciate your opinion and I will go according to it, or I could say, nope, I still want to go to court. But it does help me know whether or not I have a chance really of winning, right? Because usually arbitrators are like attorneys or retired judges. They're people who have a lot of experience with this sort of thing. And it helps you get a sense of whether or not you really have a case. But other times there's what's called binding or mandatory arbitration. And that, actually, binding arbitration, mandatory means that you sign a contract agreeing you'll go to arbitration before you go to court. And that means that whatever decision the arbitrator makes, you're stuck with. And the courts over and over again have said, if parties agree to arbitration, we're not going to overturn it. Why? Because they agreed to it by contract. Each of you probably at this stage of your life has been a party to a mandatory binding arbitration clause. You don't realize it, but if you've ever signed an agreement for a cell phone or for a credit card or for a bank account, in all of that fine print, you agreed that if you had a dispute with the bank or the phone company, that before you could go to trial, you would have to work with an arbitrator, and that the arbitrator's decision would be binding. So you've all agreed to it in the fine print at some point, probably. Maybe some of you never done it. Your parents did it on your behalf when they got you your cell phone. But so that's out there, and a lot of people do it. And that's all I have for this chapter. Anyway, any questions about it? It's kind of interesting stuff. What's hard about this class is there's a lot of interesting, but it's also a large volume, so it gets a little boring and bogs down sometimes. So hopefully it's not too painful to go through it.
Can you help me understand? In the literature, it says that a judge